I'd like to start the meeting with the Pledge of Allegiance. Pledge of Allegiance to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Yours or mine? Mine? I didn't put it on because when I stand up for the pledge, it takes me right down. Okay. I'm Jerry Catino. I'm acting chairman tonight. Roger Menard is not with us tonight, and so I'll do the best I can. I'd like to call the meeting to order. It looks like it's 6:35 p.m. Under Mass General Law 30A, Section 20F, this meeting is being recorded and on both audio and video. I might mention that when you use the microphones, you're not really amplifying anything in this room. That is for the purpose of the television and the taping. I'd like to note that when the floor is open for public comment later on the proposal, those people commenting will be going to the microphone and identify yourself with your name and your address. Also, in order to ensure that any part of the hearing is completed in a timely fashion, we encourage those people speaking to not repeat concerns that have already been submitted for consideration, and that includes in the prior hearing. We don't want to go through all of the things new again tonight. Okay, the first hearing, I will read it. It's a 18 McKinley Street, continued hearing of the application of Tammy Therian, applicant, and Tammy Therian and Keith Therian, owners, for a special permit to convert the second floor of the existing garage into a detached accessory apartment containing 800 square feet, pursuant to zoning bylaw Article 9, Section 9.5.4. The property is located at 18 McKinley Street, Westport, Mass., and is shown on Assessors Map 11, lots 557 to 594. We held this hearing previously, and this is a continuation. The applicant needed to get some paperwork for the, I believe, the Board of Health or whatever. Could the applicant come up here and we'll go through the hearing?
You want to state who's voting?
I'm sorry, please.
State who's voting?
Oh, yes, okay. George.
No, me.
Oh, I'm sorry, that's right, the other way around. Barbara, myself, Connie, Ray, and Cynthia. Okay. Okay, so you went and got some paperwork, approvals and so
Yeah.
forth. You want to just let us know where you stand?
Yeah, so the town, I did this bedroom walkthrough again with Joe Reese, and he gave the information back to Matt, which the health department signed off on, and as far as I know, the Conservation Commission also signed off on it.
Okay, so has the bedroom renovation been done or just going to be done?
Yep, it's all done.
It's all done,
Yeah.
okay, so you've got a letter of approval from the Board of Health that they're,
So Maria,
Yeah.
they
You
have
have
an email
emailed it
there
to
somewhere.
Maria.
okay, all right, well, I won't bother to read it then. Anyone want me to read that email? Okay, all right, then, I guess at this point I'll seek a motion for 18 McKinley Street.
I'll make a motion to approve the special permit for Tammy Therian and Keith Therian to convert the second floor existing garage into a detached accessory apartment containing 800 square feet pursuant to zoning bylaw Article 9, Section 954. And the property is located at 18 McKinley Street, Westport, Mass.
Okay, second? Okay, we've moved and seconded to approve the application. All in favor?
Aye.
Aye. Any opposed? No? Passed. There's a 20-day appeal period, so you can't technically do much of anything in terms of renovation until that point, anything that needs a permit. So once that appeal period's over, it's 20 days from the time it's filed with the town clerk, with our decision.
Yeah,
It's filed with the town clerk.
okay.
And you got the deed restriction, and you've
Yeah,
worked that out
Maria
with
just
Maria?
gave it to me, yes.
Okay. All right, thank you.
Okay,
Good
well,
luck
thank
for
you
you.
very much.
Good luck to both of
Thank
you.
Thank you very much.
Cold.
Sunset Road, Harbor Road.
I'll be there for this. Are you there for this?
Okay, I think we're ready for the next hearing. This is a continued hearing for 435 Old Harbor Road. It's an administrative appeal of Kevin Brayton McGough, an amended administrative appeal of Kevin Brayton McGough and Ryan Kim from a determination by the building commissioner that the use of the property at 435 Old Harbor Road for educational service would be allowed, provided that the planning board approves the site plan as mandated by zoning bylaw Article 8, Section 8.7. The subject property is located at 435 Old Harbor Road, Westport, Mass., shown on Assessors Map 87, Lot 2. Voting on this one will be George, Barbara, myself, Connie, and Ray. Okay. We also have with us our town council, and we will be hearing from him as well. So at this point, let's see, do I have you go first, or have the applicant?
I'm happy to if you would like. I think the last time we were here, I had opined to you that I didn't believe that that person appealing necessarily had standing. And I also opined that the issue before you was a preliminary opinion or advisory opinion at which you typically don't have jurisdiction to make a determination on. The decision of the building inspector that alleged to, or the advisory opinion says, after review of the Westport zoning bylaws, the use of the property at 435 Old Harbor Road, Westport, Mass. For educational service would be allowed, provided that the planning board approves as per section 8.7 site plan approval. Building permits will be required for any alterations or additions to the existing. The applicant, in a letter that was provided to me this morning, has agreed. He says that the applicant's May 19, 2023 letter applicant meaning, I don't believe the appealing party, but the applicant's May 19th, 2023 letter requesting I don't know what it's a typo. A does not include a detail of the primary and secondary purposes, proposed uses for the property. It is clear that the zoning officer's letter was advisory only and sought to state in broad strokes the thrust of the zoning ordinance, as you know, it's a bylaw, but ordinance regarding educational uses and is not applicable to the various facets of the proposed project. In other words, he agrees that this is an advisory opinion that essentially has no precedential value. As I advised you guys last time, I think you should dismiss the appeal. It is not right
Can
before you.
we clarify who he is? Because
The person who, the appealing party here,
Well,
Mr. McGough
could I
and,
clarify one thing?
I don't think, he's, if I don't look at him, he doesn't look like he's willing to stand down, so I have a,
Just a moment, sir. I'd
Okay.
like to clarify that, I believe the letter that partially that Attorney Blake was referring to was a letter we just got
from
today.
Mr. McGoff's
Okay.
attorney,
So,
and Mr. Kim's
so,
attorney.
that is where he's picking up some of that.
Okay.
But it was only today that we, well, it came 4:30 yesterday in an email, but obviously the office was closed, so we got it today. So have you each had an opportunity to see that?
No.
email?
No, I didn't.
All right, so.
We should have the applicant come in front.
I'm going to-
I don't think he's,
I'm going to do that.
I think he's just asserting that it has no weight, but I don't think he means he wants,
I'm going to
Just to be-
ask them.
Okay.
with all due respect, I don't think it's his determination as to
Yeah.
whether or not you move forward with this appeal.
can I ask a
That's
question?
your,
Can I ask-
that's up to you.
Can I ask
not
one
to
other
him.
question?
Sure.
Well, two things. One, I believe Mr. Webster isn't even the property owner, so could he even get a binding letter from our town building inspector? Or even submit a planning board site plan? I thought an owner had to do that, and he's not an owner.
No, I think, which is oftentimes the case, somebody who's looking to
Perspective.
buy the property will request the necessary permits. I do think that they need the assent of the property owner.
Yeah, but it appears to me, in my mind, that Mr. Webster is asking us, the town, the zoning board and the planning board, to do his own due diligence. And I think, I just wanted to make that
I
statement.
guess I don't know who Mr. Webster is.
He is.
Weber.
Weber, okay.
Weber, I'm sorry.
He is the individual who wants to buy this property and do this project. But he
Well-
doesn't own the property, and he's been asked, he's submitted a site plan to the planning board, and in my thoughts, I thought only an owner could do that. And to even ask our building department to act, if he could do something, I don't think it's appropriate that our building inspector should have even replied.
Well,
As a
that,
non-property
That
owner.
goes to the rightness of
that
this.
goes
Yeah,
to
that's
the
what I mean.
rightness of it.
Right, so-
We're going to get into
I mean, I
that.
think there's a lot not right here.
Yeah, We're
So-
going to
so-
get into that. I'd like to give the applicant, for the appeal, I want to be clear here, we're not talking about the applicant for the project, we're talking about the applicant who's appealing to us to come forward, please.
Mr. Chair, I'm Steve McGilvray. I'm representing
Have a
the
seat,
appellants, who are Kevin McGough and Ryan Kim. If I can step back a little bit and just say, I think that the three options for the board tonight are to overturn the letter, to send it back because it doesn't address many of the complexities. It's basically 5 words of this letter are the underlying applicant wants you to believe that that's an approval of the entire project and all of the complexities of that project and uses. Or the last option you have is to basically say, this is just advisory, it's a nullity. He doesn't have approval yet. He would have to come to the zoning board for a special permit to get approval, not right to the planning board. So let me first talk about standing, because that was raised at the last hearing. I'm going to talk about the standing of both the people who are appealing and the standing, which was just raised by Mr. You've got a name that's harder than mine. Kozakowicz?
Very good.
Yeah, well, that's from McGillivray. It's learned to read all the syllables. So first, the standing of the appellants. Mr. McGough has standing as an aggrieved party. I know your town solicitor said perhaps he doesn't. That's an interesting issue. We can talk about whether he's aggrieved and whether his property suffers a particular harm. I don't think you have to get there because Ryan Kim has joined the appeal, who's a direct abutter. So that makes that issue of standing, I think, very, very simple. He's within the 300 foot
300 feet.
300 foot perimeter. He's presumed to have standing. I think that's fairly easy. The standing of the underlying applicant to actually apply is a little bit more interesting. under the bylaws, you have to be an owner to apply for a permit, to get planning board review. Or you have to be under agreement. So, you know, if you have a PNS, you can be considered what they call the equitable owner, and you can come in and you can get. Here we have an applicant who says they have a purchase and sale, but I don't think anybody's ever seen it.
Could I interrupt you for a moment,
Certainly.
please? Because I don't want to prolong this any longer than we need to. You're talking here now about the standing of the applicant. The applicant, for a site plan
Yep.
to the planning board is not the subject of our discussion here tonight whatsoever. We are only here to discuss the appeal of the letter of the building commissioner. And so I don't really feel we need to get too deeply into
Sure.
planning board, because that's nothing to do with it. Planning board's already held it. If they found something detrimental to the application for their site plan because it wasn't signed by the owner or whatever, that's their business. It's not ours. Secondly, we're bringing up the issue of standing again, and unless there's a reason for doing so, I think we've gone past that, because we have a co-applicant now on there, which I had wanted to see done primarily just to clear that issue up, so there's no longer any potential of, is he a bona fide abutter or applicant for appeal or whatever. I think we've gotten by that now.
Okay.
If you feel I'm wrong, I'd like to just
No, I think
hear
that the question of whether the appellants, the people who are appealing tonight, have standing, I think is resolved by the addition of Mr. Kim. So
that's
the reason why I raised the standing of the underlying applicant for the project is because there's a real question as to whether they had standing to even ask the zoning officer for a letter.
Oh, you're talking about the applicant for the project?
Yes.
Not this,
That's
to
correct.
be clear.
It is, so I'm gonna use appellant and applicant. Appellant will be my clients,
Okay.
and applicant will be the person who's proposing the use on the site.
Right.
Um,
But we're not here right now to deal with the applicant's issue of site plan.
That's correct.
That's going to be with the planning board, and has been.
So what my comments were directed to was whether the applicant actually has standing to even ask the zoning official, zoning officer.
Okay,
For a
not the
letter.
planning board, but the zoning.
That's
Okay.
correct, which is the subject of the appeal tonight. So that's why I raise it,
Yeah,
that,
let me clarify that.
sure.
Ralph, when they discussed, the applicant for the project discussed with you, was the owner
No.
there at all?
The owner wasn't there.
Okay, that's an important consideration then,
The
okay.
letter specifically says, my client is considering buying this property and wants to know.
Okay, yep,
And typically you would see, in the case of an equitable owner, someone who doesn't quite yet own the property but can stand in the shoes of the owner, they'll come forward with a purchase and sale agreement so that the town can make sure that they are in fact standing in the shoes of the owner. Not anybody can come and just ask for permission to do something on a piece of property. They have to have an ownership connection to it.
correct. I would like to go back to your first contention of 3 possibilities that
Sure.
this board can do tonight. I don't think I heard you say anything about the issue of ripeness. Could you, do you want to address that, or, because we're being advised by our counsel, and we should listen to him, he's our counsel.
Not everybody listens to their lawyer. I can tell you that.
We do.
You know what they say about fools and all that, right? Anyway, and I believe a very applicable one is this issue of ripeness,
Yep.
because there's nothing there that shows that this was a decision, the letter from commission. It was an advisory.
Sure.
It was building anything, not looking for an occupancy permit or anything like that. So I think the issue of ripeness, I love that word ripeness. That's a legal word. And
It's not a farming word.
yeah, and so I'll keep repeating ripeness of this situation. So that says to us, if it's not a ripe situation, meaning it's not ready to be acted upon, then we don't need to continue past that issue.
Yep.
So I don't know if you want to.
Yeah, I think here's the problem. The applicant has proceeded to the planning board, waiving this letter and saying, I have permission, basically. It's been determined already that this use is as of right on this parcel. So if that letter is just advisory and the applicant is incorrect about that it's not binding and it doesn't resolve all the issues that you've all heard about, if that's the case, it has to come back to the zoning board at some point. It doesn't just go to the planning board for planning board review.
Right.
It's the zoning board's purview to say what educational service or educational uses is. It's up to you guys to define that. So they need to come back to you in some format. It might not be ripe today, but they need to come back to you and get either a special permit or some kind of determination from you that this is a use that can take place on this parcel in a residential area. Without that, it's, boy, you're shortcutting the system even further, right? Now he doesn't even have a letter, it's an advisory opinion, he's going to the planning board and trying to proceed just on that.
Right.
So I think if this board, and I don't think you'd be wrong to do it, follow your council's direction and say it's not ripe, I think that your order also has to contain something that says you need to proceed by special permit to the zoning board so that we can consider it in full after an appropriate hearing of all the issues.
If they chose to go forward with this.
If they choose to walk away, then we're not gonna stop them.
Right.
Yeah.
So that's the key there, is I think that needs to be addressed first, is the issue of ripeness and what to do about it. Just to bring you up to date, the planning board did meet on this, but deferred any action
Right.
whatsoever until after this hearing.
Right.
Actually, the planning board deferred because their peer review of the application had not been provided to them until shortly before. It wasn't. wasn't the plan.
And they wanted to know if it was a proper use before they went ahead.
That's not what I
Yes.
said, but
Yeah, yes, I watched it 3 times,
Yeah, I
you
did.
watched it.
that's
It
not
was-
the email I got.
Well,
But that's fine.
that's what they
was-
said.
that
They're
was
saying,
my
we are
takeaway.
not going to move forward. Let's not get through the weeds until we know this project has a chance to go forward. It's not going to get squashed by the zoning board. So,
Well, the zoning board has no,
yeah,
if this is an educational use, and the project, the applicants say it's an educational use, in order for them to get any type of determination, any type of permit, they have to get a site plan review. Then they would go to the building commissioner and ask for either a building permit, or they would build and they would get a certificate of occupancy. There is no special permit requirement here. There is no, this is what I'm trying to say to you, until there's an actual controversy before you, you don't have anything to go before you. The building commissioner makes the determination in the first instance, and he does it to the extent that he typically does it through a application for a permit. Now, if they go to the site plan review, the site plan review under your bylaws is appealable under 48 section 17. So if the planning board makes a determination and grants site plan review, then these folks will then have standing to put it before a court.
A court,
And-
not us, right?
That's right.
But generally, this is not the way this goes. The cart's before the horse right now.
Yeah.
In my opinion, there's no building permit and no letter denying the building permit for certain reasons.
There's nothing
But
to
does
be
he even need a
appealed.
building
Correct.
permit?
So this ripeness thing
Yeah,
is kind of,
my question is, does he even need a building permit?
Or a
He's gonna-
certificate of occupancy.
He'll need a certificate of occupancy. That's a lot. But what I also have, I'd like to just be able to say we don't, that it's not right, but, the planner basically in his email to the applicant said, you need an official letter by Ralph. And if our town planner is saying that, I know that we're not the planning board, but we have an official in our town saying you must go to Ralph and get an official letter saying it's a use. To my mind, then the town planner thinks it's an official letter, but we're saying it's not. And I think,
So,
I think there's another, this is beyond this issue here, is that the planning board and us are not talking very well back and forth. And if they're calling it an official letter,
so the planning board is looking one way or another for
They're
the
looking
use
at it-
issue, the use issue to be resolved before they take it up.
yeah,
But
And
this letter does not totally resolve
So
the
maybe what
usage at
you
all.
could do is option 2, which is remand it in a sense back to the zoning officer to make a more complete determination. Because this is an educational facility according to the applicant, but it has other uses as well. And there's a question as to whether it's really an educational facility or is that just a label that's allowing them to evade scrutiny. There's also the question of whether a for-profit educational facility is exempt from the zoning laws. So those are real questions that I think you can send back to the zoning official, get him to do a binding letter, and then let's have we'll appeal it if appropriate, and then we'll be right to proceed before you. You can handle the use issue, and if you handle it in a way that's positive to the applicant, then they can go to the planning board for site review.
I don't know that, first of all, I don't think I've ever seen a planning board remand back to the zoning official an advisory opinion. I believe the opinion that was given by council at the planning board, town council at the planning board meeting was that you have to look at what you have before you and make your determination based on that. And if it meets the site plan criteria, it meets the site plan criteria, you approve the site plan with conditions if you think appropriate. And then somebody can appeal that, or they go to your building commissioner for a building permit or whatever permits, other necessary permits are needed. But I've never seen somebody appeal, I've never seen a planning board remand it. And it also gets, the issue that I have are these advisory opinions. And that is to have the zoning official at this point give an advisory opinion. As you can see from the letter that he drafted, he essentially stated the law.
and not the interpretation of it.
And not the interpretation thereof. Also, I do want to, I'm not going to get into the merits of whether or not profit and for-profit matter in this instance. But I do think that it's an advisory opinion, and for all the reasons that we're talking about right now, the board shouldn't entertain it, because we just don't know. We don't know what the project is. We got a 397-page information from the project the beginning of the week. There's a lot of things that need to happen, and I'm sure
The
that
sale
they'll be
has to go
explored.
through. The lot has to be subdivided, and the sale has to go through for anything to happen. I mean, there's a lot that has to happen before, I think the applicant has put the cart before the horse by going to the planning board for an official planning approval. I think
You had to. So that all speaks to the ripeness situation. So I would just like to,
he needs to buy the property first,
I would like to mention to the
because might not even get.
public
You don't have to go to
here.
split.
I'd like to mention to the public that at the last meeting, you may recall that a motion was made to basically dismiss the whole thing. And there was some concern expressed by the applicant for this appeal about that. And so we reconsidered our thing only to give all of you an opportunity to express yourselves, to see if we couldn't find out more about the project and find out what some of your concerns or positive aspects of it or whatever. So my intention tonight is not to repeat all of that. There's no need to. We did that as a courtesy to you folks as a public, so that we could get it on, get some of these things on the table. We also suggested that maybe you guys ought to talk to each other and see, get more detail of the project and so forth. Right now, I think it'd be appropriate to address the rightness situation, because if it's determined by this board that this is too premature, all right, then we go no further. We just do it, and then, as has just been spoken of, there'll be a time when, if this project were to go forward, there'll be a time when there'll be certain permissions from the town, approvals, whether it be site plan or building department, or septic systems, or whatever it may be, that would need to be taken. And at that point, when there is an actual decision and an actual project, then this type of activity would be in order at that point.
Can I ask for a little clarification on that? Because I do think the use has to be determined whether it's an appropriate use. That's a threshold issue. At what point, because the planning board is not going to do that, my concern here is by saying that this is an advisory opinion, you're essentially giving a green light for the project to continue through.
You also, I believe, said it's an advisory opinion.
But only because it needed to be either turned into an actual opinion, or the zoning board had to handle the use issue. So my question is,
Yeah.
when will that zoning board handle this? If it's not right now,
When-
when does it become right?
When there's something in front of us. There's no plans in front of us, there's no building
Right.
permit, even the planning boards is, we're playing tennis, back and forth.
Sure.
Well, there's nothing for us to make a decision on, with the exception of the appeal itself.
Yeah.
Do you want to address
I
the
did- I- no, this-
ripeness?
No, I don't want to address the ripeness. I want to ask you for permission for the appellant's attorney to discuss with us why he thinks the 5.1 educational use is not, that he needs to read in the Dover Amendment to 5.1. We gave Mr. McGough the ability, and the rest of the people last time they were here, to speak their mind, and I think I would like the board to hear his arguments regarding why he doesn't think the educational use, not even, that the applicant is the 5.1, that we have to read the Dover Amendment into that. There has to be a not-profit organization. I'd like to hear what you have to say about that.
Well,
You did mention, I think it's just as important as Mr. McGough talking about what he did before. I think it's something that I would like to hear, and hear the attorney's argument. So when this does come back to us, we have had some time to mull it over, because I think it's a very complex issue, and I think if we wait until they're back for whatever, because when they appeal the building permit, I'm afraid that the board will not have the ample amount of time to consider it. So I think having him just spend, let's say, 5 minutes to give him his take of why he thinks, based upon our zoning laws, that the Dover Amendment should be read into 5.1, and that the applicant needs to be a non-profit organization. I think that'd be important for us, for when we're down the road.
Okay, I would agree with that. However, I would like him not to repeat stuff that was dealt with at the last.
No, they didn't deal with
So
it
as long as
because
there's new information.
this is a legal argument and which Mr. McGough was not
Yeah.
capable of making.
I agree, I would like to hear that. I think it also might be instructive for the planning board.
Yeah. So,
If they watch our videos.
do you want to?
Happy to go forward with that, and I'll try to be as brief as possible. The case law is fairly clear that it's the purview of the zoning board to determine what the meaning of the words in the zoning bylaws are. And so when you have an ambiguity, the zoning board has to fill in the gaps. And educational uses in 5.1 is not really defined. It just says educational uses, which could mean a number of different things in a number of different
It's
contexts.
not defined in the bylaw.
That's correct. So now it's up to you folks to figure out what that actually means. In the absence of an express definition, the meaning, and I'm quoting from a case here, the meaning of a word or phrase used in local zoning enactment is a question of law to be determined by the ordinary principles of statutory construction. So when people try to interpret statutes and they're ambiguous, they go back to, hey, what did the people who make this statute, that enacted the statute, what were they trying to accomplish? Sometimes they'll go back to the congressional record and see what the discussion was before a bill was introduced. Why did they introduce this bill? And that will inform them as to what the bill was meant to do. Here, the intent behind the educational uses, boy, we wish it was a little clearer right in the bylaw, but they do tell you, they give you a hint, hey, this is why we put this in here. And that's the footnote 3 to 5.1. And it says that this amendment, which happens at the same time as the Dover Amendment, this is happening to comply with the Dover Amendment. So now you know they left you an indication why they put educational uses in there. They wanted to mirror and comply with the Dover Amendment. The Dover Amendment, if you look at that, yes, it allows educational uses to evade the normal scrutiny of municipalities for a project, but only when the land is owned by a nonprofit organization. All right? So maybe back when the Westport enacted this, they thought all educational uses were not-for-profit, didn't really contemplate that, but they were trying to basically mirror the Dover Amendment, which they were required to do. Here, we have something that's at least purported to be an educational use. That's another topic, whether it really is primarily an educational use or not. But it's for-profit. They've admitted that the property owner will be a for-profit corporation. So it's up to this board ultimately at some point to make a determination. What does educational uses mean? Does it mean anything that anybody says slaps the word education on it and it's good? Or do we have to dig a little bit deeper? And if we dig a little bit deeper, do we make a difference between nonprofit or governmental entities that are doing educational services? And do we distinguish those who are doing it to make a buck in a residential area? And I think the Dover Amendment's pretty clear on that it's only nonprofit landowners who get the benefit of that part of 5.1 and the Dover Amendment. So that's it's a short encapsulation of the argument. There's the other side has cited a number of cases, but your town solicitor can look at them. They all have to do with nonprofit educational services. So that's a real problem. And then there's the other problem that I think you ultimately will have to decide, which is this just a lipstick on a pig? Are you just calling it an educational? Are you just calling it an educational facility because that's the easiest way to get it approved?
Now, at one point, you used the word primarily education.
Yeah.
And I think that's an important consideration
I
as
think
well.
it is.
And our town council has some thoughts on that.
Yeah. So I think there has to be a time, because the planning board, my understanding, is not going to consider whether the use is appropriate. there has to be some time when that comes back before you for full vetting. Our position is that should happen first, because you don't want to go through the whole project review and not know if the use is appropriate. You want to know the use is appropriate first, and then you go through the project review. If, however, you're getting advice that you wait till the building permit is issued before you start talking about whether this is even a appropriate use, we can do it that way as long as it's clear that that's when we get to come in and present this argument to you.
As far as, I think if the building permit is issued and it's appealed, then certainly they have the ability to appeal and they'll come
Okay.
before you. You know, I don't necessarily want to do the applicant's work here. However, I will say that with respect to the educational use, the footnote number 3 is a footnote that we put in a lot of bylaws, because if you put educational use up in the use table and the AG sees that, they will oftentimes strike it because the Dover Amendment doesn't allow you to regulate an educational use. With respect to the determination, the not profit versus nonprofit aspect of it, I certainly understand that, and I even said it at the last meeting, that there does not seem to be any case law on a for-profit educational use. What we do then is we try to look at, as my brother said, because this is not defined, we go to the cases and try to find out what an educational use is. All of the cases that deal with educational uses are Dover Amendment cases. Dover Amendment, he is correct, says nonprofit. However, in my opinion, the corporate structure of an entity does not have anything to do with the use, whether or not it's educational or not. You just would look at what are they doing, not if they're making money. In fact, some of the cases say that it doesn't matter. You know, you don't look at the person that are being served. But also, when we go back to the zoning bylaw, I think we could also get a lot of, we can also get some help there. So, under the institutional public portion of your zoning bylaw, there are a number of uses. There's club, private, not for profit. All right. So the drafters of the bylaw, if they want to constrain to just profit or not for profit, they know how to do it. They did it with this one. The next one is club, public, conducted for profit. So again, they know how to distinguish them in your use table. Convalescent homes, educational uses, and here we go again, public or private golf courses. They know how to do it if they wanted to. We don't have that in front of an educational use or a convalescent home or a hospital or natural gas distribution. Although I'm wondering if natural gas distribution would ever be not for profit. Nursing homes, public utilities, none of those have and sanitariums have a distinction. They've distinguished clubs and they've distinguished golf courses. So statutory construction tells you that if they're distinguishing in some, they know that they could in others, and therefore it's unlikely that they
I think
meant to
did.
distinguish it.
I think they did. I think that was, I would guarantee those were all in there before the education. The education got put in there because of the Dover Amendment, and they just assumed that when you put the little reference to Dover Amendment, that has to be read for nonprofit, and that's the way I read it. I came to that conclusion 4 days ago before we got Mr. McGough's, your letter. And I think you have to read nonprofit into our bylaw.
And I do think I would look back at the corporate structure is the important aspect. I mean, if there's a difference between a for-profit entity and a not-for-profit entity, and and that part is key. So if the corporate structure is a for-profit corporate structure, it's a for-profit corporation.
Yes.
It's a for-profit entity.
Absolutely.
Right.
But that doesn't change the use. If I get money to,
It does.
if I'm a private school.
No, it doesn't change the use, but
So
it changes
you-
how we read our bylaws, and I think we have to read nonprofit into our bylaws.
I would-
That is my opinion.
Okay.
I would look at that one again. Anyway, so that's the, I think the issues that are gonna have to be taken up by this board at some point. Again, I think it should be done before the planning review, and that's the way I usually see it done. But as long as it's gonna get to you for full vetting of these legal issues at some point, and we'll have to live with that and do it at the, I guess when the building permit's gonna be issued.
It would get to us only if someone chooses to appeal it.
Understood, yeah.
Okay, so,
It's just that what
Did you
is,
wall it out?
what is the appealable event is
Yeah.
the question.
is there more to be said about the, what you wanted?
No, that's, I just wanted you all to hear his argument, because I thought it would be something for you guys to, everybody to fester on as we wait for this to go through the process.
Does the board have anything that you want to comment on regarding the prematurity or the lack of ripeness of this situation?
I'd just like that-
We don't have something in front of us to appeal.
I'd like to, Ralph, you want to weigh in on this?
Sure. It's just that no building permit has been applied for. I don't really know what they're gonna come forward when they do apply for a permit.
Correct.
I tried getting some of it, I did a site visit to it, I tried to get some of it out on a site visit with the planning board members. I came out of there with nothing, I mean, all they said it was like, we got the right to do this. I said, what are you doing with the buildings, what's in the buildings now? I really wanted to get into the buildings, see what they were, and it didn't happen. Stood out in the parking lot for a while, and then we left.
Can I ask our attorney something that was brought up by the appellants and Mr. McGough last time with respect to our zoning bylaws, but only allows to have only 4 people non-related in a housing unit, and how does that apply to an education, a boarding school, which is what we, if this is indeed an educational use, and they are boarding there, one would argue that's a boarding school, right? And how does that fit into our zoning laws and the Massachusetts
Lodging
code?
house statute. I think that it would have to be a lodging house to be limited to the 4. I think that if you read your zoning bylaw, you have sanitariums, you have nursing homes, you have hospitals and the like. I think
That doesn't require a limit of,
Yeah.
okay.
That's
I
right.
just wanted some clarification on that.
I would like to,
Ralph?
The building code would take it the next step if they were to apply something, because I'd be asking for code synopsis to tell me how many people are in this building. What is this, you know, spell out what's gonna happen there. You know, if it does come before me, I'm gonna want a building code synopsis on the use and the property.
All right, Connie.
as to the ripeness issue, I think it is ripe in regards to if the appellants had not contested this at this point. It seems to me that via the planning board, it would have already been a done deal.
Well, not necessarily, because
Not at all.
there's hoops that they gotta go through there, like qualified kitchen, parking, lighting, you name it.
But
There's a,
that's already down the road, and
right, I agree.
Yeah.
Yeah.
I mean,
And we
it's-
would have had plans in front of us that we would be making comments on.
well, we might not have been, because there might not have been any reason to bring it before the zoning board if everything was signed off of by the planning board, as it appeared that it was going.
No, it can't. You
No,
can't,
the-
right, Ralph? It's
the
gotta
planning
go,
board
can't go that
cannot-
way.
The planning board cannot sign off on the usage
Correct.
of it. for
But
one
that
Has to
thing.
come to
wasn't
us
being
to make
brought
a
up.
decision,
But that,
after a building
The
permit.
planning board is only dealing with the site,
Right,
they're not dealing with the use.
lighting,
But it didn't-
parking, things like
it
that.
didn't sound like the use was going to be questioned, that it was
Not
going.
with them, they're dealing with the site.
We're the only ones that can question
They
it.
won't- They won't question the use will be questioned. when it's-
Ralph determines that initially,
But
and then
Ralph-
if people don't like what Ralph did, they're here, that's why
Well,
they're here tonight.
right, exactly.
So it would get vetted out.
It just seems that it's,
Ralph,
I
did
think
you
we
make a
all feel that it's
determination?
going too
Excuse me,
far.
Cynthia. He started to
Yeah.
talk.
Ralph, did you make a determination as to whether or not what they're proposing to do, the use was allowed under your bylaw?
No, because I don't I didn't have what they were gonna do. It was a general question.
But your letter seemed to indicate that, that it was by right, since it was an
I just
educational
took it
institution.
right out of the bylaw.
It is, education is by right.
Right, but,
He did not make a determination if the use is.
That use was
It's
educational.
Yeah, not
They
on
just asked him
that- on
they asked
that
him
project.
the question, is educational use okay? And he said yes, which is correct, except they didn't really ask the right question, because they didn't want to ask the right question. They didn't give them enough information to make that
It's allowed
determination.
right across every district in town, site plan approved by the planning board.
Yeah.
Educational uses.
Yeah.
That's what they asked me, is it an educational use? Site plan approved, but then also, they didn't ask me anything more than that. They asked me that, and they didn't tell me what they were gonna do.
Yeah.
So I couldn't go any further than that. I just answered what they asked me, that's it.
We didn't even know until the hearing of this group how many people were going to be in there, because the question was asked, and when Attorney Burke was indicating what he considered the facts of the case, and someone asked the question, how many students would there be? And I can recall them saying, well, let me see, two in bedroom 1, bedroom 2, and a total of 12. It was determined right here in this room.
A number of 14 was mentioned at the site visit.
See?
Is
So,
this typical for it to, because it does, I mean, it does seem a little ass backwards, right? Like, you're gonna say, they're gonna go to the planning board, they're gonna spend our planning board's time and money because they had to get a consultant, and the planning board's gonna say yes, and then they're gonna have to subdivide the property, which has to come, maybe come before us, because, right? Because they have to do the subdivision of the property. And then he's gonna have to buy the property. And then there's the issue of the fact that part of the property is in Little Compton, we can go there. And then they're gonna ask for a building permit, right? That just seems a little ass backwards, right? Does all towns require, there's no,
Advisory opinions?
nothing to do with, yes, an advisory opinion on,
Typically, they don't.
No.
There's,
they wait for the building?
yeah, they
Yeah.
wait for something at least concrete, as we're all discussing here tonight.
It's
We have
very,
we have no idea really what's
Yeah,
gonna be before you.
it's very loosey-goosey,
And
because,
as, you know, and I'm glad Ralph was here, that your building commissioner was here, because at the last meeting, there was a question as to whether or not he was actually opining on the use in an earlier letter. Tonight, you've heard, he was not. He was doing exactly what the letter says. He was simply saying, educational uses are allowed in that district with a site plan review from the plan,
right out of the bylaw.
Yeah.
right out of the bylaw.
and I think for us to not to, I think it is, in my opinion, I don't think the issue is ripe, and I think actually to opine on it and make a decision that's counter to our rules is actually only benefiting the applicant and who is not a Westport resident versus the appellants who are. I mean, we're basically doing his due diligence for him. And I think if this is a project he wants to do, he has to make the decision if it's risky enough to go ahead and go through all the expense of the planning board and buying the property and perhaps getting a building permit denied. And if it's not denied, he knows it's going to get appealed. That's clear, and that's for him to decide. And I don't think us making a decision one way or the other to make his job easier or more secure in his investment is really what we should be doing here.
Did you want to
If I could,
identify yourself?
my name's Ryan Kim. I live at 445 Old Harbor Road. When the leaves fall, I can see all these buildings from every room in my house. So I'm very close to this. I have kids. And I'm very grateful that Kevin McGough filed his appeal, even though there were questions about his standing, because as you said, Constance, that this would have been already sort of a question of just parking lots and permit and septic tanks, not whether this was allowable in a residential area. So I'm super grateful to Kevin. But regarding the ripeness, I guess it seems like I thought I heard from the first hearing, which I wasn't at, but that Richard Burke, the developer's attorney, also was relying and wanted that letter to have more import than it than just sort of an opinion, because I think they're spending real money and costs on permitting and advisors and consultants and now legal fees. And it feels like, Ralph, I know you have a lot on your plate, you've got a lot of other duties in Westport, and you're not an attorney, and you didn't even get a satisfactory tour of the facility. You sat in the parking lot and then wrote the letter, but it just seems like, this is the right body to talk about zoning, and so I'm a little surprised that we're gonna go through these motions of like spending money on, permitting and consultants with the whole zoning question. I think everyone agrees there's very fundamental zoning questions that are open here about nonprofits, and so it just seems super inefficient, and to force, Kevin and I to spend attorney dollars, to kind of go through this again, and when we're already here, it does seem frustrating to me. I don't know if that's just the way it works in towns and in Westport, but that is, I think both sides agree that we want, I thought I heard Richard say last time that he wanted, that they were relying on this as an approval, and that they were going forward and spending money as such. So it doesn't seem fair even to, this notion of ripeness doesn't seem fair even to the developer. So and Ralph just admitted he didn't get an adequate tour and had information. He's not a lawyer, so can Ralph rescind his letter? Is that an option, to rescind his letter, or do we have to go through all these motions?
The letter's non-binding. I think we all are clear as about that. So I think, yes, someone's gonna have to spend a lot more money to get this before us, and luckily it's not gonna be you guys, it's gonna be the applicant. It will be of you eventually.
I would like to address directly what you said, okay? I want to be clear that Ms. McGough was advised by our clerk, long before he actually applied for this, that it's premature. Nothing had been issued yet, and am I correct, Maria, that this was, okay? So we're not looking to waste your money at all. We're quite the opposite. But we can't act as lawyers for you either, to say you should do this or do that or whatever.
And we
But at
can't act
least
as lawyers
even
for-
our application strongly advises every applicant, for whatever, whether it be variance or whatever, to seek professional advice before coming here.
I guess my only concern is, as Mrs. Geese, is it G or G? I'm sorry.
G.
Gee said, if Kevin hadn't filed his appeal, I think it would have come down to parking lot drainage and septic tank size, and that doesn't seem right to me. I mean, thank God that he filed the appeal. So I don't know, it seems like there was more reliance than
Well,
that,
I don't
right?
think it would, because you do have the public processes, and hopefully you can stay on top of what's happening and take appropriate action at the appropriate time. But right now is not the appropriate time, because we don't have anything to act on.
I do think you've made your points,
So, absolutely.
and you have brought this to the public's attention. And I'm sure that the planning board is paying attention to this as well. So you have achieved,
A goal.
yes.
Yeah, and it'll allow us to resolve this a lot more efficiently and probably more accurately according to the law when a building permit is either issued or denied and there's an appeal.
Okay.
So I don't think you've gone in vain here.
Okay, thank you.
Yeah. Anything else?
I don't have anything.
Okay.
Is there any way, there's a timeline here, and they did spend quite a bit of funds of doing this appeal. Is there any way, other than how do they get notified that a building permit's been issued? Do they have to keep calling the building department? Is there any way we can?
Yes, I think that was brought up at the hearing, that they could go to the building department and ask to be
Right.
notified.
Yeah, I think that would be appropriate
I
in
believe
this
that
case.
was brought up. That could happen, right, Ralph?
The first, and also the first thing that has to happen is the site plan review there has to be a determination on that,
Yeah.
because it
That's
requires site plan before Ralph can issue a
Right.
building
I
permit.
thought it went the other way, Ralph, right? You first and them second?
No.
No.
Planning board is then first.
That's the problem. But yeah, so if they, to appeal the planning board's site plan decision, they have to go to real court, not state court, which is here, right? And that's definitely more of an expense. And there really there really isn't gonna be that much to appeal because planning board rules don't rule on use, and that's the key issue here, right?
Well, I'm not going to opine as to whether or not, how for them to do, but yeah, under your bylaw, you can appeal it.
But
Under
you can appeal
48,
it
section
to
17.
to us?
48, section 17.
Okay, you can appeal it to the zoning board.
No,
You can appeal to the land court.
that's the way I read it.
Yeah,
48,
me too.
section 17.
Do any other board members or anyone else here have any comments?
Can I ask one question?
Sure.
So is it the board's position that no zoning, that there could be no letter or determination by a zoning official that would be appealable to you with respect to use? Do you know what I'm saying? Could this letter, what would have made this letter different that would have made it appealable to you? Or are you saying letters and determinations by the zoning official are never appealable to you?
Oh, I'd ask for legal assistance there. My own personal view of that would be that if they had come in with a document, a set of documents together that said, we're gonna do this, we're gonna do that, here's some plans with it, and so forth, and after reviewing all of that, Ralph signed on to that, saying that, then I think I would take a different view of it. But even that would not be an issuing of a permit, that would be an opinion.
And it would be appealable at that point.
Well,
I think it would have to be a bind, something that would be
Yeah,
binding.
a
And I
binding
don't
decision.
think an advisory opinion, a zoning board, a zoning administrator's letter meets that standard. A lot of them don't give them.
Right. But those that do, again, if we had not appealed this letter would have gone to the planning board and they would have assumed that the use was permitted and they'd be, so. Anyway, that's neither here nor there, but except for it may affect how we move forward in the future in terms of.
And if we say it's moot and dismissed, that's without prejudice, so they can bring another appeal on the same issue.
Yeah, because it's not the same issue.
I don't think
I
it
just
would
wanna
be
make
moot.
sure-
I don't
yeah.
think it would be moot. I think you would say that it's not, that there's no controversy before you. It's not ripe for determination because it's an advisory opinion.
What options do we have?
You have the option of denying it on the grounds that I just said, that there's nothing before you. You have an option of, I suppose you could grant the appeal. You could deny the appeal. I think a grant or denial would require significant amounts of time and energy to determine what the actual proposed use is, and I don't know.
We don't have enough information to
I
even
don't know.
determine
I
that.
agree.
Right, so we can't deny or accept the appeal because we don't know enough about what the use is to even make a decision.
Unless you read the letter as saying that educational uses are allowed after a special or a site plan review under 5.1. That's what that letter says, and that's a true statement.
Mhm.
So the letter's not wrong.
No,
It just
Not wrong.
doesn't mean
And
anything.
didn't really need it from Ralph. I think he should have gotten it from an attorney.
And it's incomplete.
Well, it's incomplete because that's all, he didn't, there was no
Right,
information
not-
given, right?
deliberately.
Like, yeah,
Deliberately, yeah.
yeah. I mean, in my mind, if I was buying a property, what I would do is I would go to an attorney and say, here's the town, here's the zoning bylaws, what do you think? And give me an opinion.
Right.
I wouldn't go to the building inspector.
Right.
He's not an attorney. I mean,
I think, at least for our family, and I think a lot of the direct neighbors, our biggest concern is not 12 adolescents, getting mental health and substance abuse treatment, but it's the unfettered, aspect of it, like with no zoning definition whatsoever. The developer's prior facility in Falmouth, he sold in 4 years and was bought by, a big private equity firm and has totally changed from what he built. So I think we're okay in theory with something that's not for profit and has some limits to expansion and is done the right way, but it feels like a blank check that, and that's I think our biggest fear, and it feels like this is the body that should define the zoning, not the planning, but the zoning restrictions on this concept, and it is frustrating, and I know it's no one's fault, but it is frustrating that this is gonna go back to if it goes back to planning, and then we have to go to a court, and it won't even come back to this body, it sounds like, is that right? It would go, we'd have to.
At the time that the building permit's issued, it would.
It would come back to this body, or it would go to?
Well, if he issues a building permit because he claims it's an educational use and they've met your bylaw by getting a site plan review, then you would have the ability to say, no, it's not an educational use, and you could appeal the permit at that time.
Or
But not
Ralph
here.
can deny
That's right,
deny the permit, and then they can appeal saying that it's
Yeah.
a matter of
Yeah.
right.
Right.
Exactly.
Which is,
Right.
So somebody's gonna get a crack at it. It's likely gonna come up to these guys.
Okay.
I want to just ask the board members, would you like to hear any new information from the general public? Or do you want to proceed with potential motion to basically consider it not ripe and we go no further?
Well, I think if the general public has new information, we should ask them to come forward. If
Alright.
not,
I
I'd like
would,
to ask one
yeah.
question. You said that they built a facility in Falmouth, and 4 years later they sold it. Did they make, and they made a bunch of money when they sold it? And now
I
what
mean, I
is-
don't know, I don't know if they made
or you
money,
know
but
how-
they
you don't know
sold it.
exactly how much. And what is it being used for now?
So I met with Ken Weber, and we toured the property after the last, I had not formally joined anything, and I was trying to make my own assessment. We toured the property on Old Harbor Road. I also asked to see his prior facility in Falmouth, and I don't have the details of whether he made money, but he said, well, we can't go there because it's changed a lot since I sold it, and it wouldn't represent what I was hoping to do. And that was our
but it's
concern.
actually worse fear.
Yeah, that's our fear. It's like in 4 years, we're still there and he's gone, and,
So they could do that here.
I mean, it's certainly a possibility. I don't have any details, but I know that
It's still a facility, it's still a rehab,
it is a similar,
similar type
it's in
of,
Fountain,
as much as we know about this project, it is sort of a holistic rehabilitative. Okay, it's a go.
Okay, pause. But, I asked to see one of his other facilities, and he said we couldn't go there because it had
And
changed.
is that in the residential district?
I don't know anything about it. I didn't drive by
It
it.
was a converted motel, it's in a
Okay.
commercial district. He did one in Falmouth and he did one in Sandwich.
you want to come up to the microphone?
Yeah, 'cause I thought he had said the other day, well, I wasn't here, but I watched the tape, that the other projects that he has worked on have been in residential areas. And it appears that at least the one in Falmouth, it was a motel, I don't think it was, but.
It was a strip motel.
Excuse me. Who's talking?
They said the applicant was present.
Oh, yeah.
Okay,
I-
well,
There we
I got a gentleman here that's got his hand up. Could you go to the microphone, please? I'm trying to keep the discussion to the ripeness of this activity. So if you've got new information, go right ahead.
Tim Rennie, 303 Old Harbor Road. I've been at both, a couple of the hearings, and actually after your last hearing, speaking with town council, my question was then and still is, can the zoning board of appeals basically not necessarily change the letter, but qualify or make clear what I'm hearing, everybody's agreeing to, that it is only advisory and not an approval?
Yeah.
And to have that in the record, so that Ken Weber can't say, well, we thought we got approval. And, in other words, make it clear what I'm hearing, that it was advisory, it's incomplete, and still do whatever you're going to vote on, but write that into the record.
I think we have to when we say
Yeah.
why it's not right.
That was all my,
Well,
that's my
it
comment.
will be in a couple of ways. First of all, we have minutes of the last hearing, minutes of this hearing, and minutes will become official records. And if the board member here makes a motion tonight about this, that can be included in that motion, that because that it's only advisory and so forth, we consider it to be only a not ripe
Yeah.
situation. So yes,
I think that would be
could put in
important to consider that, especially since Ryan's correct, having been here, that Attorney Burke did publicly take the position, which he might even be prepared to defend or litigate,
Right.
that they considered this an approval letter.
Right.
Thank you.
All right. Is there somebody else? I thought there was somebody else back there.
I'll be succinct, and thank you. Arthur Sweetser, 34 Worcester Point Road. I'm not an attorney, I have too many around me, but they do talk about intent. And that's what I take away from here, which is that the intent was to call what is a rehab facility, which I support, a school. And you are a zoning organization, and whether you like it or not, you've weighed in on it, because a letter, or however you want to interpret it, is being interpreted as a way to get what the developer wants. And that's, as a neighbor and person, that's my observation, which is that you're kind of in it because this is the intent of the developer, which is to use the school clause to get through, which, as the attorney both agree, it's not a profit. So to me, I do think you have a responsibility tonight not to kick down the can and to say, this is what the intent of this letter is, or not, because somebody's going to potentially build based on that. Thank you.
We're not kicking a can, by the way.
It sounded like that to me.
We don't have any can to kick.
Well, but you're in it. The letter is there.
Point is.
The appeal is
And we
there.
just addressed that a minute ago
All right,
on how
all
we
right.
could handle that.
Sir, Kevin Vendatuli, 686 River Road. When you were speaking earlier, you said that it might change your determination if there had been a back and forth over the proposed use and that had sort of been out there and it may have had some meat to it. I would ask you to pose that question to the proponents of this, maybe the real estate agent, because my understanding is there were 3 meetings, hours long, on that issue. That's my first point, and I'd ask you to ask that.
I'm not quite understanding, I'm sorry.
With who? 3 hours with who?
With the building inspector and Attorney Burke and
I don't think Ralph gave 3 hours his time anywhere.
I put any 3 hours in,
what
3
was
hours to
the,
spare.
I'm not supposed to act directly across or ask directly across is my understanding, but was there a back and forth over the
Yeah.
use and what
But
it
even if it was
consisted
a
of?
verbal back and forth, what I was saying was my own personal opinion was that if there was a full document that had everything spelled out and all the plans, everything, and then he signed on to it, I would maybe view it a little bit differently, but not just on the basis of what he said or she said.
That's the question that I'd have you ask them, is whether that went forward, just because that seems to be determinative in your mind. And I can't answer that question.
Yeah. But we do know that there are no documents such as what I'm seeing.
Okay. And then the second issue that I'd just throw out there is, by making a determination that's not ripe and allowing it to proceed through planning, are you not essentially doing exactly what they sought to do from the beginning?
What, who sought to do? Well, I guess my view of that is that they should get, legal assistance, which they've gotten, and anyone appealing should get legal opinions and so forth, to fight it if that's what you would intend to do, which is happening. That doesn't change us not having anything before us of a actionable piece. There's no decisions been made by it. No decisions for anyone to take any action. If they, the applicant for the project, wants to consider that as a go-ahead, well, let them. If the planning board wants it, let them, but that's not a legal thing, at least from our point of view.
My last question, this may just be me being a little bit dense and not having looked into it, but if it's an appeal from the issuance of a building permit, where's the use aspect that is going to be appealed?
He will say the building permit's denied because the use is not allowed. There's two ways. He's going to issue a building permit, and you're going to say, you're going to appeal saying the use isn't allowed for all the reasons and probably more than you've already told us. Or the building permit is going to be denied because Ralph is going to say the use is not allowed. And then they'll appeal it and say it's matter, right. That's where the use comes. That is when we determine use.
Okay, and I apologize, that's probably a novice question, I just wasn't sure.
No, it's very confusing as to all of us too. But I mean, so in the first case scenario, the appeal goes to land court. On the second case, the appeal would come back to
Yeah.
us.
Yeah.
No,
No?
if it
The
denied-
building permit, the appeal comes to us.
That's right.
Yeah, that's
The
what I said.
planning,
That's the second.
the site plan goes to land court.
Yeah, I'm sorry, you said
Yeah.
site plan. I didn't mean, yeah, site plan goes to the land court.
Right,
And then-
Or Superior Court.
right.
Right,
That
but
was the
again-
first option, the
Right.
second option.
But again, planning boards in the Commonwealth of Massachusetts does not determine use, so
Right.
there would have to be something a little bit more concrete in what's wrong with the planning board site plan approval was. Like maybe public wells, septic, something or other.
So it never gets addressed.
Yeah. Yeah, it doesn't get addressed.
It does when a permit from Ralph is issued, though.
Only if he denies it.
Either, what's that?
Only if he denies it, right? I mean,
No.
well, either way, but.
Yep, either way.
Right.
Either way, and it could be a certificate of occupancy as well. Let's say they don't need a building permit. I think they probably are going to, because they're gonna have to remodel the inside, right? They're gonna need one.
Change of use.
And change of use. So there will be an application that comes before him, and that's when it,
Right.
That
It does, it's unfortunately, it doesn't make sense, but that's the rules. I mean,
for the reasons that we're going through right now.
yeah.
Do you know what's before you? Do you know what that uses of that property is?
I'm sorry?
Do you know what's before you and what the use of this
Well, I know
proposed use?
what I read in all of the different documents that have come before us, and I think it was fairly clear that the for-profit business is a substance rehabilitation center for adolescents.
Okay.
Yeah.
I mean, that seemed, reading through all the documents we got, I think that was pretty clear.
Yeah. And then you have to go to the case law.
Yep.
And that kind of says it's a traditional.
Yeah, I know. Big time.
Yeah.
Okay, any other comments?
There's only one distinction, profit or not profit.
Okay, seeing none.
Can I just
Yeah.
make a comment on,
Sure.
Mr. Simmons? Just on terms of what the form of motion will be? I just want to make sure that we're throwing the word advisory around, but really the letter is a nullity, at least with respect to this particular project's use. It doesn't make any determination either way.
It's non-binding.
Non-binding, and your decision to dismiss the appeal is not without prejudice to further appeals. In effect, the letter issued by the zoning official has no effect, no legal effect as to the use. I just don't want to go back to the planning board and have them say, well, they get an advisory opinion that's 80% of the way towards getting an approval. So I just want to make sure whatever motion you put together is dismissed without prejudice to future appeals, and that the underlying issues have not been adjudicated by this board.
We will have our town council advise us as we go through the motion of this motion, no play on words.
My name is Philip Weinstein. I live at 93 River Road. I'm
you a
also
lawyer also?
Excuse me?
Are you a lawyer also?
I am a lawyer.
You seem to have...
No, I'm a lawyer, and I'm fascinated about what's going on here. I was not at the last hearing, but obviously this has been
Kevin?
this has been a very interesting conversation from my point of view. So I did have a question. Is there any precedent in the town or in the Commonwealth where a party not being an owner of a parcel of land can come before a zoning board asking for an advisory opinion when, without going through the process of I am the owner. And I know it's an expensive proposition, and I know it's a risk if they're going to put the money down. I honestly think this matter, if people really want to take it to its logical conclusion, this is going to end up in probably the SJC. This is going to be a long, drawn-out legal process. There's going to be transcripts, there's going to be records, there's going to be a litigation, there's going to be examination, there's going to be cross-examination. What is the real purpose of this? The citizenry, I'm not personally taking an opinion because I don't know anything about it other than what I've heard. But as a lawyer, I would say, listen, we have a legal process here. And to be fair to everybody, there has to be a proper hearing, a proper record. And I just don't know that there's been ever a case before or a situation where people are coming before a zoning board saying, I don't want to put the money down, but tell me if I do, okay, you're gonna give me the green light. And the citizenry have a say, because this is going to end up in a court where there may well be appeals, and and I know that we need a record, and we need the whole process to go through it. So you're playing with it's a big deal.
We're gonna make him do the money, because he's gonna
I
have to be an
understand that
owner
completely.
to get a building permit, and then the money's down, right?
Yeah, so and I'm looking
So-
to the litigation that's going to go forward if they really want to do this project.
I'm happy to answer that question.
Response from town council.
And my answer is, yeah, it happens all day, every day in the Commonwealth of Massachusetts.
Okay?
Non-owners who are
Then if that's the
looking,
case-
hold on, who are looking to do projects, want to come in and get something in writing from a zoning official, so that if later on, then they can use it. That's why we always advise our people, don't give it. Or if you give it, you do exactly what Ralph did.
Yeah.
This is what our zoning bylaw says. You don't, there's nothing binding about that. You're appealing the zoning, you're appealing his determination to the extent that it was one, then these guys would have to uphold that. His determination is 100% correct. It doesn't have any effect on the project. It's simply a restatement of, it's like me saying that you can't kill people. Duh, it's murder. But to answer your question, yes, it happens all the time. And the developers and those that do that, they do so at their own peril.
So what, if I understand you, what you're saying is, if they go through the process with the planning board, with the building inspector, with the planning board, they can then come back here requesting, an opinion.
Nobody comes to these guys and requests opinions.
We're only an
That's-
appeal.
Yeah, that's not their,
Or an appeal.
that's not their role.
Yeah.
If building permit's issued, the neighbors appeal. Building permit is denied, the applicant appeals on zoning grounds, and up it comes.
And if it's granted?
I just said that. If it's
Yeah.
granted, then the neighbors appeal.
But not to us.
Yeah.
Yeah, they
Well,
appeal
the
to us,
neighbors
yeah.
would come to us
Yeah,
first.
but building
But they
permit.
have to go to, but they have
Building
to go to
permit. If a
land.
building permit is issued, you guys can come back and appeal that decision, and then and only then will we make render an opinion, a decision as to what the use is and as if it is allowable in our zoning laws.
I thought you just said that they had to go to land court.
That's
For the
for the
planning
site
board,
plan.
the
Site
site
plan
plan,
review.
not the site plan review, not the building permit. The building permit comes back to us.
This is not how it normally goes. I've been on this for a while, and we've never seen this. But I don't want to see this down the road that some other neighborhood has something else going on in their neighborhood, and let's appeal this before they even get going.
Yeah.
Because it's not how we operate here. And I can't really say to Ralph, hey, would you like to change that letter? Because the letter, like our attorney has said, is correct.
Yeah.
That's right.
And if we did change that letter and we
If it
gave you an
said, if it said
opinion,
you're gonna put a treatment facility, and that was in the letter, he probably would have said, no, you can't do that. Maybe he would have said that, I don't know.
It's not our job to do Mr. Weber's diligence, right? So therefore, if we even asked Ralph, if we could even ask Ralph to change the letter, that's what we're doing. He's using our resources to do his diligence. He's got to do his own diligence if this project is worthwhile and is in the guidelines of our zoning, and take the risk that it may not be when it comes to time of getting a building permit. And I would rather see him take that risk and take on that expense than you guys take on that expense.
Thank you.
Especially
Appreciate it.
not being a property owner in this town. I mean the appellant, the applicant, not me. I'm a
Thank
property
you.
owner.
Can I hear a motion?
I have something here.
Okay, town council will, I'm sure.
You want to give me,
be-
can I give it a whirl?
Yeah, go ahead.
I make a motion to dismiss the administrative appeal of
Wait a minute,
Caton.
Hold on,
What?
Cynthia. Because.
Oh, I'm not
you're-
voting, I
you're
can't
not-
do it.
Yeah, you're not
Damn.
voting on it. Well, you can assist your fellow board members in
You can say
drafting the
I'll read
motion.
it.
And
along
somebody
with-
just says so
You can't
moved.
read my hand,
Along
right?
with town council.
You can say it, and then somebody can say so moved.
Right.
Oh, okay. Will someone so move to dismiss the administrative appeal of Kevin Brayton McGough and Ryan Kim with respect to the property located at 435 Old Harbor Road as not being ripe for appeal, as no decision has been made by the zoning enforcement officer as to the use of the property. The letter issued on June 12, 2023 is merely an opinion and non-binding to the zoning board of appeals.
So moved.
Should I do it
I
again?
think that's fine. I think that's
Just the
fine.
way it is?
Yep, yep.
Okay, it's been,
I'll second.
okay, it's been moved and seconded. Any discussion? Hearing none, all in favor, say aye. Aye. Opposed? None? Okay, so it's been moved and passed. So I'm not sure, is there an appeal on something like this, or we just dismissed it
It's dismissed.
on a dismissal?
I think that they probably could if they wanted to try to appeal it and say that it wasn't, that it was ripe and that you
Okay.
should have, but
All right, so you could appeal. So I guess, what, 20-day appeal again?
exactly right. Yeah, once we
Okay.
put out a written opinion. Yep.
All right, well, I appreciate the interest that all of you have shown in this and your input, and hopefully the best will come out whatever happens. So again, appreciate it, and thank you all very much.
Thank you all. Thank you very much. That was a very,
Thanks for your time.
Thank you.
You've done good, Jerry.
Thank you. Appreciate it. Appreciate you.
This
Hopefully
would be
we
the
won't
most
see each other again.
exciting
I got a
thing
feeling
to
we'll
find out that they won the state championship.
Maybe it'll disappear.
Thanks so much. I know this took a lot of time, but I think we looked forward to it.
I made a binder.
When you go to town meeting, double our pay.
You gotta talk to my wife and let her,
Which is still zero.
she's gonna let me do more stuff.
It looked like ping pong when you watch these meetings.
Okay, could you take your conversations out in the corridor?
Yeah.
We have further work to do.
What'd you do, break it?
So,
Make a decision. There was two meetings on it. The first one and this one.
yeah.
Not the second one.
Jeff, while we can't continue, can you hear me? While we can't continue doing the thing, just a quick question. If we have a situation like this, can we put a sign on the door?
Yes.
That,
Open session, come
Open
in.
session,
Yes.
come in?
Yeah.
Because we've always been told, oh, you can't close the door.
You're
you
not
can't-
supposed to, right, but you're supposed to at least let people know that, because a lot of times in the summertime, when we got ACs
That's another
running,
issue.
we'll shut a door and say, AC, door shut for AC, open meeting, come in, or something like
Okay,
that.
all right.
Yeah.
That would be
I
helpful.
think that's an important thing to remember for you folks, not for me, because I won't be here. but Anyway.
Where are
Okay,
you
so we
going?
do have, on the agenda, it's got the approval of minutes from the November 1st meeting.
I think
I'm done.
What actually happens now?
The planning board can do it. Site plan or not,
And then it gets a building permit.
and then you're supposed, well, then, no. Then they have to actually buy the property.
They gotta buy the property first before they start making any of this. They're not gonna do that.
That's the thing, he hasn't bought it, right? So it's not, and he's not buying all of the property.
Well,
we have to
we'll get the
discuss
executive
this.
session.
Jackie then changed who the butters
Well,
are, right?
the minutes will be quick. Okay, I want to talk about the minutes. We have the minutes of the November 1st meeting, which was this hearing, and I've been going through it, and there's some things, well, first of all, let me preface it by saying that I believe that these are a particularly sensitive set of minutes because of potential litigation and so forth. And I think that we need to make sure that we're saying things correctly and.
We haven't gotten those, have we?
What's
I
that,
looked for
please?
them, I couldn't find them, the November 1st ones.
Well, so anyway, you're actually working right into what I want to say. I'm going to suggest that we hold off the approval of the consideration of these minutes until the next meeting, which we're allowed to do. We have the proper time frame to do that. And this way here, like in my own case, I'd like to look at the meeting tapes again and see, because it didn't seem quite right.
They're juicy, I watched them
think
3 times.
Yeah, so anyway, I'm just suggesting, anybody object to holding off the approval of the minutes until the next meeting?
No.
Okay, all right, so we'll bypass that. Okay, so now I think we're going into executive session.
November
Just one more
15th.
thing, there's the planning board request.
Oh, I'm sorry, yeah,
I don't know if everybody saw it,
I got it right here.
that little subdivision.
Okay, the planning board has asked us to comment on a, I'll read it here. Definitive subdivision plan entitled Definitive Subdivision Plan, Rosewood Lane, Westport, Massachusetts, prepared for Emmanuel Pacheco and located on the westerly side of Gifford Road between 225 and 247 Gifford Road, map 29, lot 22C, proposing to divide the property into 2 lots. A public meeting is scheduled for January 9th, 2024 in the Annex Conference Room over at the Town Hall Annex. Your response, meaning our response, is greatly appreciated no later than December 15th. Anyone have any thoughts on this plan that you would like to make any comments to the planning board for their consideration?
And just as a note, that came in like yesterday, which is why it wasn't on the agenda.
Yeah, I haven't
It wasn't on the
I haven't
agenda.
had a chance to look at it, I mean,
No,
is there?
It just came in yesterday, the request from the planning board.
doesn't,
Okay.
it probably shouldn't be bringing it,
Okay,
if it's
so-
not on the agenda, it's probably,
Okay.
should be done.
Okay, I didn't realize that.
We don't have a meeting before January 9th,
Correct.
so I just put there that no, we could put other, received too late for
That
comment.
doesn't come under within the 48-hour? Okay.
It's gotta be
I
an
didn't know.
it's gotta be an or unforeseen, and
Well,
Yeah.
no comment.
Yeah.
Yeah, so we can
They
just,
should kind of know when our meetings are.
I mean, on the surface of it, without knowing more about it, I don't think a two-lot subdivision, as long as it meets the, you know, their requirements. it's gonna-
That's what happens sometimes with these, is even though I might get them and put them on the agenda, by the time they want comment, we don't have a meeting, so we end up, you know, I do send emails out to all the members if they want to come and look at
Yeah,
the plans,
Yeah, okay,
so.
yeah, you did send,
Yeah, but that was, I
That's
just
not the
got
one
that
I thought it
yesterday,
was.
so that's why it wasn't on the original agenda.
okay, so, is there anything else on the agenda besides the executive session? I don't think so. Anyone else got anything to talk about? Okay. Then, I've got to go through the spiel of the executive session.
What is that?
Is that your hearing aid? That's squealing, or,
Okay, so, I
Go in
guess,
first and then she'll shut it off.
yeah, that's what I said, we vote to go in and then she, okay.
Yeah, sure.
All right, so I'm going to read the item for the executive session pursuant. Do we have to actually make a motion? Motion, right? Well, I'll move that we go into executive session pursuant to General Law, Chapter 30A, Section 21A3, to discuss the land court litigation regarding 50 Spinnaker Way LLC, where discussion in open session will have a detrimental effect on the town's litigation position, and the chair so desires.
Declare. Yep.
I'll second that.
Okay, it's moved and seconded. We'll take a vote to go into executive session. This will be a roll call vote. And
And we're not coming out of executive session, right? We gotta do something for
Right,
that too.
we will not be coming out of executive, we will not be going into open session after this executive session. But I gotta determine the voting on this, right? So,
No, everybody does.
Yeah. Typically, we all vote, I'm not sure why, but.
You can. I
Can
mean,
we all
to go
vote?
into executive session, you can certainly.
Really?
anybody
Okay.
can vote.
okay.
Do we have to close the open meeting?
yeah, we have to close.
No, you're good. You just have to,
Yeah, yeah.
so moved, and now you do your roll call, we're in.
So moved.
Okay, all right. Okay, so roll call vote, starting with George.
Yes.
State your name and your vote.
George Stelgis, yes.
Barbara Pontilillo, yes.
Gerald Catino, yes.
Constance Guy, aye.
Rail ISI.
Cynthia Zachowitz, aye.
Okay.